Hi, my name is Eileen Mostricht, and today I wanted to talk about this question of whether or not you should have your estate planning documents redone if you move from another state to Florida. So as we all know, there are lots of people who have made Florida their permanent home in the last few years, and I get questions almost every week about whether or not they should redo their estate planning documents from their other state. So the general rule is that your estate, as long as your estate planning documents were properly executed in their state of origin, then they will be accepted here in Florida. For example, some states require 3 signatures on a will. Florida does not, they require 2. So if you have a will from out of state and your state required 3 signatures, but you only got 2, if you bring that to Florida and then you pass away in Florida, even though we only require 2 signatures, that will is not going to be accepted because it was done in a state that required 3 signatures. So as long as it was executed properly in that other state, then it's fine here. Now, would you want to revise them? Maybe. I mean, you have to, of course, review them to make sure that the people that you've named as your agents are still the people that you would want to serve, and and also whether or not your disposition, how you want your assets distributed at your death, make sure that's still the same. So if you want to change those things, obviously, we would amend or tweak those a bit. The one document that I do recommend that does get redone in Florida is the durable power of attorney. In my opinion, this is the most important of your estate planning documents. This is the document that names somebody to handle financial matters for you if you're alive but incapacitated. Super important. So if you have a stroke or you're in a car accident or Alzheimer's, whatever it is, and life goes on, bills need to get paid, things need to get done, and somebody needs to talk to somebody on your behalf, for example, your IRA company or your homeowner's insurance or agency or your HOA person, they're not going to be able to speak to that person without a power of attorney for you. So, and if you don't have that power of attorney, the solution, the only option at that point is a court guardianship, which costs several thousands of dollars. It's very intrusive, something totally to avoid. So do your power of attorney. But if you have it from another state, yes, I do suggest that you redo it. Florida is pretty specific about their requirements in the power of attorney. And also, if you want your agent to be able to do everything that they could possibly do for including Medicaid planning for you in the future, that power of attorney has to say certain things. So yes, if you move to Florida, I do recommend that you redo your power of attorney. Your other ones, it's optional depending upon whether those other ones still meet your wishes.